أعوذ بالله الشيطان الرجيم بسم الله الرحمن الرحيم. So before the break, we were talking about the importance of business law to entrepreneurs and the managers, and we also gave the difference between an entrepreneur and a manager. And we said that the business law basically helps the entrepreneurs and manager to do what? It normally guides them when they are making decisions, and it also guides them in issues related to risk management. So these two elements are very important when it comes to what? When it comes to law, the importance of law. So understanding business law helps prevent disputes. If you understand the disputes, then what is going to happen? If you understand business law, you're also going to avoid disputes, and you're also going to ensure compliance, and it will also at the same time do what? Support sustainable growth. Now, a good example is a manager who understands contract law can avoid signing unfavorable agreements. So, for example, you are a manager and there comes a contract that you have to sign. But if you have a good background in the law of contract, you'll be very keen enough to read throughout the contract before signing it. But a manager who is not good in contracts or law might end up signing something that might bring problem to him or her in the future. Now, the next part of our lesson, which is also very important, is about the legal system and court structure. Remember, we are talking about business law. We are talking about the legal environment of business. So we need to know this legal system. What is it and what is the court structure? So number one, let us start with the legal system. What do we mean by the legal system? And when you're talking about a system, think a system of a group of interrelated organs that are working together, to achieve a given objective. So think of a system. A system always have an input, process, and output. So when you're talking about a legal system, what is the input of a legal system? What is the process? And then what is the output? So a legal system is an organized set of laws, institutions, and procedures used by a society to do what? To regulate behavior, number one. Two, resolve dispute. Then lastly, enforce rights and obligations. So this system consists of what? It includes courts. So courts are part of the legal system. Judges, part of the legal system. Lawyers, law enforcement agencies, rules that guide how justice is administered. So all of these items and people, they form the ecosystem of the legal system. So, for example, commercial laws and courts that handle business dispute are part of the legal system. The commercial law and the laws and the courts that actually determine issues related to business dispute, they are part of this legal system. Now, court hierarchy. Also, when you're talking about business law or the legal environment of business, you have to know some issues related to the hierarchy. When you're talking about hierarchy, we are talking about the level or classes. So court hierarchy refers to the structured ranking of courts according to their authority and level of power. So for example, if you go to the law courts, their power, their authority is law. If you go up there to the Supreme Court, then they have their powers is they have a high authority. So if you have any business case or dispute or conflict that is minor, so lower courts handle minor cases. So if something is just minor, you cannot go to a Supreme Court with something that is minor. While higher courts hear serious cases and appeals from lower courts. So this is how it goes. We normally have the the law courts. Sometimes they are called the magistrates court. So they will hear your case. If your case needs a higher authority, you'll go to it is called the high court. After the high court, we have the court of appeal. After the court of appeal, we have the Supreme Court. Supreme Court is the highest. It has the highest authority. It is the top of the level there. So, for example, a small contractual dispute may start in a magistrate's court. Magistrate courts, these are the courts fil adna, the law courts. While major cases go to the higher courts. Sometimes if the case is very serious, you don't even have to start with the law court. You go immediately to the higher court. So as a businessman, somebody who's doing business, you have to be familiar with how these courts operate. Now, jurisdiction of courts. What is the meaning of jurisdiction? So when you are talking about jurisdiction, we are basically talking about you knowing the courts and knowing the boundaries of the court, both in terms of content and context, because courts are not the same. You have civil, courts. You have criminal courts. So there are different types of courts. Inheritance court, the Kadis court. They deal with different issues. So you have to know the kind of court to actually address your issues. So when you're talking about jurisdiction, is the legal authority of a court to hear and decide a case. So for business cases, you have to go to commercial courts. That is where they're going to help you. But if you're having an issue with business, and then you are going, for example, to a criminal court, or maybe you're going to a Kadis court, the Kadi is not going to help you. So courts have this jurisdiction based on subject matter. When you're talking about subject matter, we are talking about the case, the content of the case. Is it related to inheritance? Is it related to contract? Is it related to crime? Geographical area. Every area has a court. So you have to know, for example, if this case happens in Mogadishu, can you actually go to a court in Boro or any other place? Or you just have to start with the court in Mogadishu? So you have to know all those things. And the value or seriousness of the case. So another issue that determines jurisdiction is how serious is this case? So for example, a labor court has jurisdiction over employment dispute, but not criminal cases. Anything related to employment, you go to a labor court. You cannot go to a criminal court. Now, what is the relationship between court hierarchy and jurisdiction? So this refers to how a court's position in the hierarchy determines the type of cases it can hear. So lower courts have limited jurisdiction. That is the magistrate's court, while higher courts have broader and appellate jurisdiction. So the high courts, they have a broader jurisdiction, and you can even appeal to the higher courts. So a case filed in the wrong court may be dismissed for lack of jurisdiction. So sometimes you go to the wrong court with your files. They'll tell you, hey, we cannot handle this case. Our court does not deal with this case. So they're just going to throw your file. Now, another issue that is also very important is we normally have these two words. We normally have civil liability and criminal liability. So what is the difference between civil liability and criminal liability? So civil liability arises when a person or business is legally responsible for causing harm or loss to another. So civil liability is when one person or business, legally is legally responsible for causing harm to somebody. The harm can maybe be in terms of money, monetary harm, or contractual harm, you can name it. So it involves private disputes. and seek compensation rather than punishment. So anything that is civil, like we can deal with it like gentlemen. We cannot, we don't need any punishment. I just want you to compensate me for the mistake that you have done. For example, a company breaching a contract may be ordered to pay damages. A company breaching a contract, tomorrow we shall talk more about breaching contract. Breaching a contract means you are going against the terms you agreed in your contract. So if you go against the terms, you are supposed to deliver a product by Friday, you did not deliver, then you have to compensate me for the loss that I have incurred. So in civil liability, civil, it deals with people, private people, and there is no punishment that is involved. But criminal liability occurs when a person or organization commits an offense against the state or society. So in criminal liability, it is between you and the country, or it is between you and the society. While the civil, it is between people, me and Mohammed, me and business A or B, it is civil. But criminal, now the government has to come in place. So there is punishment. You are going to be arrested, So the purpose is punishment, number one, and deterrence. Deterrence means preventing something from happening again. So it is not compensation, unlike the what? Unlike the civil one. So, for example, a business owner convicted of tax fraud may face imprisonment or fines. So, for example, if your business is not paying tax for 4 or 5 years, now that is between you and the government, and they're going to take you to a court of law. They will arrest you. You can even be imprisoned. So that is the difference between civil and criminal liability. So civil and criminal liability differ in purpose, procedure, and outcome. So civil cases aim to compensate. This is the key one. Tafwid, it is known as what? Al-iwad, or what? Civil cases aim to compensate victims, while criminal cases punish. هناك العقاب. So civil cases use the balance of probability, while criminal cases require proof beyond reasonable doubt. So civil cases use the balance of probability. يعني لو كان احتمال, maybe you did not understand, maybe, هناك الاحتمالات. But when you come to criminal cases, if you take somebody, if you take somebody to a court of law, if you want somebody to be arrested, then you have to show, you have to give us evidence beyond reasonable doubt. If there is a CCTV camera, if there are witnesses, all those parties, they have to be part, So, for example, an employee injured at work.
Compensate victim.
What? Sorry? So an employee injured at work may sue for damages. That is civil, while the employer may be prosecuted for safety violation, which is criminal. So this is the difference between civil and criminal. An employee, for example, I am working at a company. If I get injured while working in the company, I'm going to tell the boss, you have to compensate me. While the boss can be prosecuted with the government, so that is criminal. So in one place, in a company, you have a case being civil, and it can also it can also have the criminal part of it. Now, alternative dispute resolution. Alternative dispute resolution refers to the methods of resolving disputes or conflicts outside the formal court system. Sometimes this is where the elders, sometimes you find in the society we have the council of elders. They will tell you, oh, don't go, please, don't go to the court. Let us just sit. You are families, you are friends. just sit and discuss this issue. You don't have to go to a court of law. Let us see how we can manage. So this is what is known as alternative dispute resolution. So alternative dispute resolution emphasizes cooperation at ta'awun, confidentiality, and also speed. Because when the Council of Elders or a third party comes to see it, the case is going to finish quickly. But if you take it to a court of law, it is going to take a lot of what? It will take 2 years, 3 years before they finalize it. So businesses may include arbitration clauses in contracts to avoid court litigation. So sometimes when businesses are signing contracts, they can put somewhere in the contract that if there is a problem, then let us talk first before the litigation. Litigation means going to the court. So some people, they normally even put it in the contract. Okay, in case of misunderstanding, number one, let us talk. As-sulh, fasuluhu khair. Let us just talk. You know, that is the meaning of alternative dispute resolution. And there are very many types of alternative dispute. The first one is negotiation. Parties resolve dispute directly. Party A and party B, they meet in a room and they negotiate. Okay, I will do this. No, this is very high. No. So they negotiate and they agree. Number two, mediation. Mediation is a neutral third party. So if there is A and B, C, a party C comes in to intervene between the two parties. Then arbitration, we have a neutral arbitrator makes a binding decision. You know, so the difference between mediation, because somebody can ask, what is the difference between mediation and arbitration? So when it comes to mediation, you know, the third party only facilitates. So in mediation, the mediator does not decide. So he's just going to facilitate. The decision has to come from A and B. C cannot decide. But in arbitration, the arbitrator decides. So the arbitrator will say, so because the two of you cannot agree, so you have to do this 1, 2, 3, and 4. Follow this. So that is what is meant by arbitrate. The difference between arbitrator and a mediator. An arbitrator will decide, and he will convince the two parties to accept that decision. But in mediation, the decision comes from the two parties. Then conciliation, a conciliator proposes solution. Then in the case of conciliation, the conciliator just proposes also solution. It's just like arbitrator to an extent, but in arbitration, the decision is binding. Binding means the two parties, they have to follow it. But when it comes to the conciliator, he just proposes, yeah, Jama, you are not in good terms. Okay, if you want to be in good terms, I'm proposing this. 1, 2, 3, and 4. So the aggrieved parties, they have to review the proposals and agree on that. Now, what are the advantages and limitation of this system, alternative dispute resolution? So it has benefits and drawbacks. Number one, the advantages. Advantages include lower cost. Because if you go to a court with your case, you're going to pay a lot of money, you know. Then number two, faster resolution. You know, you agree on items and issues very quickly. Then lastly, there is confidentiality. So you just meet in a private place, nobody knows, you discuss, khalas, you finish. But the limitation include limited appeal options. Like there is no room for appeal. Unlike in courts, if you are not satisfied, you can appeal to another court. But in alternative dispute resolution, there is no room for appeal. Like when you leave the room, khalas, okay? يعني if you leave the room خلاص جفت الصوف قضي الأمر. And possible power imbalance. Sometimes in the arbitration, maybe there is no balance. Maybe you'll just be mesakin, the other person, maybe. So there is somehow power imbalance, you know. Now, litigation. So if the alternative dispute resolution does not work, what is litigation? Litigation, you say, halas, I'm going to the court. This case is very serious. So litigation is the process of resolving dispute through formal court proceeding. It is the opposite of the alternative dispute resolution. So it involves strict procedures, legal representation, and judicial decision. So there are some procedures that you need to follow. You need to find a lawyer, and also the judges, they have to decide. For example, a company suing another for breach of contract in court is engaged in litigation. Now, and what are the stages of litigation? For example, today, if you want to go to a court of law, how do you go about it? Number one, filing a claim. Filing a claim. So, for example, there is a dispute between you and party B, so you file. There is always filing. Then, after filing, there is the issue of pleading. So, when you file when you go to a court of law, you normally have the plaintiff and you have the defendant. So you have the plaintiff is the person who took the case, who took the case to the court. Then the defendant is the person who is being accused. So you have the accuser, who is the plaintiff, accuser. Then we have the other person, the accusee, who is the defendant. Most of the time, they both have their lawyers who are going to represent them. So they file the claim. I take you to a court of law. Then you are going to plead. Pleading when you're talking about pleading, you can say, I'm innocent, and you defend yourself. Or I'm guilty, khalas. So this is what the pleading is all about. And when it comes to the pleading, the plaintiff, you have to show the court that the defendant actually did something. So the burden of proof, you have to prove it without reasonable doubt that the defendant did the mistake. Provide all the evidence through your lawyer. Then the defendant will also defend using his lawyer. Then after that, we have the trial. So the trial, there are two different types of trial. Sometimes one judge can decide, or sometimes there is the bench judges. The judges can decide, or sometimes it is called what? What is its name? I've forgotten the other name, but there are two types of trial. Then, of course, after that, there is judgment. So judgment is when it is decided you are guilty, you have to go to prison, or you have to pay a fine. Then lastly, there is appeal. If you are not satisfied, you can decide to appeal in a court of appeal. Now, what is the role of courts in business dispute resolution? So court play a central role in resolving business dispute and enforcing legal rights. So the courts, they interpret laws, enforce contracts, and provide remedies. Providing remedies means providing alternatives or providing solutions. So for more about the lessons, you can watch these YouTube videos, and you can get a lot of information about business law and the legal environment of business. So that's the end of our lesson. If there is any question, you can ask. So tomorrow we shall just be talking about what? Tomorrow we shall talk about the the contract, the law of contract and the law of agencies. That is what we shall cover tomorrow. So please attend classes. And those who have not sent their research, some students, they have already submitted their research, but some students, I don't know, they have not yet submitted their research. Please, you only have a few days remaining before the submission deadline. So ensure. Okay, so next week will be our last week. So we have 2 more lessons remaining, I think. So I've sent the attendance in your group. Please take the attendance before the link is enabled. Take the attendance. So inshallah, we still have 2 more lessons. Tomorrow, we'll have our 6th lesson. Then next Thursday, we shall have our 7th lesson. Then after that, you will prepare for your final exam. So the final exams will be before Ramadan. Before Ramadan, you should be doing your final exam. So next week, I will explain to you more about the exams and how it will look like. Okay, so that's the end of our lesson. And the lessons, you'll find it in my YouTube channel. So if you subscribe to the YouTube channel, I always upload the lessons in the YouTube channel. So that is where you'll be finding the lesson. So thank you. We'll meet tomorrow, inshallah. As-salam.